Alrighty, this is Week People News. One more time at it. Not attorney, not giving legal advice. Educational purposes only. Alright? I'm not attorney. Okay? So, just take everything I say with a grain of salt. The best way to learn about these things is do your own research. Okay? And think outside the square. Okay? And use the Second Amendment. Arm yourself with that knowledge. Okay? Now, I thought this was an interesting one. More along the lines, do I believe I'm arm length? But it was an interesting concept of what he is speaking of. Okay? We all know, right? Your attorney is a bar member. The prosecutor is a bar member. And the judges nowadays are bar members. And it's all conflict of interest against you. Why do you think the very first thing your attorney tells you? Let's do a plea, whether you're innocent or guilty. Well, they have this evidence. They have, and they didn't even get discovery, right? So the very first thing your attorney actually ever says is, they're offering something. Do you want to take the plea? Okay, so he's already right from the start in conflict of interest in your benefit. Period. Okay. So, this other deal, we challenge jurisdiction of the court, and they just say they have it. They never said how they have it. And, we talked about subject matter jurisdiction, a personal jurisdiction, in rem jurisdiction, but they most have personal jurisdiction and subject matter jurisdiction to even begin a case on you. Okay? But when you really ask them what jurisdiction, who's the man or woman making a claim, okay, and who's the one that caused harm, loss, and damages, so I can go ahead and remedy the situation. Well, from people that maybe have unwanted substance in their pocket or whatever, we're still the victim. Where's he at? Where's she at? Right? As far as I know, they use Hell versus Hinkle, and they had their own private contract with another. All right. So this is going to be a little bit interesting of original jurisdiction by the federal Constitution.
So Article 3 is what we're really arguing. Guys, anybody that follows me should know that we're not simply arguing indictments, guys, right? We're not simply doing that. That would be too easy. That would be too simple and straightforward. What we're actually arguing is original jurisdiction. So the grand jury is a big enough deal that we can get in to have an argument. But the grand...
And that'd be a side note right there as well. The Supreme Court says the states don't have to have the grand jury. Well, the word state, with original intent by the Founding Fathers, said state means the people. Now, they changed the definition, but that wasn't the original intent. When they said state, that was the people. Okay, for clarification. And I'm not an attorney, not giving legal advice. Okay, it's educational purposes only. Look it up by the Founding Fathers of the original intent.
The issue, if you think about it, what is the real root issue there? Is it not the state or an agent of the state?
Oh, I'm sorry. Didn't even finish that subject matter. Therefore, if you don't have a grand jury, that is a violation of due process, because the people is bringing the instrument to go ahead and go through the court system. All right. That being said, the prosecutor is legal to lie to the grand jury. That's the reason why they can indict a ham sandwich. It's because they can lie to the ham sandwich and call him a hamburger sandwich. This is how stupid our government's become.
Bringing accusations against you and the judge overseeing that disposition of that dispute. So when you're charged by information, it's the prosecutor, who is an agent of the state, is bringing an accusation against you on behalf of the state. That's why it's state of whatever versus you. So the root issue is not the absence of the indictment. The root issue is, can a state be both accuser and judge in the same cause, right? Because that's really the root issue. Yes, indictment is a big problem, but indictment illustrates the bigger issue. Because when you are not charged by indictment, when you are charged by information, that is an agent of the state, a prosecuting attorney, who is bringing an accusation against you for on behalf of the state, and then it's the state that is acting as the judge against you. So the issue is not the grand jury. The issue is, can a state be both accuser and judge in the same cause? The answer is no, absolutely not. Because Article 3, Section 2 of the Constitution bars such action. Article 3, Section 2 of the Constitution, what it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. The Constitution, under Article 3, it creates two different jurisdictions for the United States Supreme Court. Two different jurisdictions. One is original jurisdiction, the other is appellate jurisdiction. Okay? So original jurisdiction means that that's the court to act first. No other court in the country can act before the court that has original jurisdiction, because that's the original court. Constitution, right after that, says in all other cases of equity and law, the court shall have appellate jurisdiction. Okay? So in all cases in which a state is a party, the Supreme Court has original jurisdiction. In all other cases of equity and law, the court has appellate jurisdiction. We're all very familiar with the Supreme Court of the United States' appellate jurisdiction because we invoke it every day. We go to that court and we say, court, please review this lower court decision because we believe that it's a court of last resort. We don't believe that it's the court of first resort, right? We don't believe that it's the trial court because never in our lifetime has that court ever been a trial court. That's because original jurisdiction was last invoked in 1890, right? This is something that's been forgotten, right? Because the Supreme Court has gone about changing the narrative, changing history. But if the Constitution says that that court is the court of original jurisdiction, then that means that no other court can have jurisdiction before that court takes action. And there's two instances in which the Supreme Court has original jurisdiction. That is, one, anytime a foreign dignitary is named a party, or two, anytime the state is named a party. If a state is named a party, then that means that the Supreme Court has original jurisdiction. Now, guys, in every case, there's two parties, right? There's a movement and a respondent. There's a petitioner and a defendant, right? So in your criminal matters, who is the moving party in every case? Read your case. What does it say? State of Washington versus you. State of Colorado versus you. State of New York versus you. The state is named a party. And if the state is named a party, then that state does not have jurisdiction because the Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. The Constitution created the obligation. The only way that this obligation can be changed is through an authentic act of the people in accordance with the special amending procedure of Article 5. Article 5 tells us how to change it. And if the Supreme Court of the United States doesn't like having to be the original court, the trial court, when a state is a party, that's fine. The Supreme Court, the judiciary, can present their case to the people of the United States and get the people to create an amendment in a lawful manner. And if they don't, then there is no change to the Constitution. So the Supreme Court has never actually changed that. That was changed by the United States Congress. and the 1935 Judicial Reform Act. Sorry, 1925 Judicial Reform Act. So in the Judicial Reform Act of 1925, United States Congress came out and did two very, very key things to cover up this right here, to cover it up. The first thing that they did is they said that the Supreme Court of the United States and all state Supreme Courts are now courts of discretion, right? Meaning that the court can use their discretion to choose to hear a case or not hear a case. They don't have to hear a case because they're now a court of discretion, okay? So that's the first thing that the United States Congress did in that Judicial Reform Act. So they said the court can now use discretion to decide whether or not to hear your case. So we all believe that the Supreme Court of the United States is a court of discretion. We believe that they have discretion to decide whether or not they want to hear your case or not. Well, even acts of Congress must comply with the Constitution or else they are unconstitutional. So the Supreme Court can be a court of discretion so long as a foreign dignitary is not named a party or a state is not named a party. If a state is named a party, then the Supreme Court of the United States has an obligation codified to oversee that because the Constitution created it. So they can't be a court of discretion because, again, you cannot use discretion with regard to one's constitutional obligations. Obligations must be performed. So if the court could use their discretion to decide to hear a case in which a state is a party, that would be an abuse of discretion to break the Constitution. And Congress can't direct them to be a court of discretion. So when you go in and you invoke Article 3 under original jurisdiction and you say state is named a party, you must hear this Supreme Court, you're not going in there asking them to hear it. You're going in there saying you have a lawful obligation to do it. Now, do you want to break the law, Supreme Court? So the Supreme Court has no authority to use discretion because discretion would be unconstitutional. So this again goes back to what I said. If the judges are relying upon an inferior United States congressional act to abridge their constitutional obligation, that's the same issue as these prosecutors relying upon inferior state statute to deprive a person of right guaranteed by the Constitution. You have the right to...
And the Founding Fathers would call that usurpation and common law trespass, common law domestic abuse, and common law battery against the people. And that itself would be unconstitutional, and that is a tyrant. And the Supreme Court would be committing treason.
Heard by the Supreme Court of the United States if the state is a party in your cause because the Constitution of the United States has created the obligation for them to do it. Right? So when they fail to fulfill their obligation, doesn't matter why they did it, doesn't matter who told them that they can do it, right? Because ignorance of the law is no justification for having it broken it. Supreme Court of the United States, you do not have the authority to rely upon an inferior United States Congress statute that directs you to abridge your obligations codified in the Constitution of the United States and United States legislature. You don't have the authority to be able to pay them to commit those crimes, right? Thus tying to the legislature like we were talking about in the beginning. So that's the first part. Now the second thing that Congress did that made us forget about this is, one, again, they said that they're now court of discretion. But the second thing that they did was they said that from now on, the only way that you can petition the Supreme Courts is through a writ of certiorari. Right? Writ of certiorari. So a writ of certiorari is a request to review a lower court's decision. A request to review a lower court's decision.
And again, that's when you're requesting something, permission, right? How you getting remedy if they deny you begging them? Sit and think about it, y'all. How you getting remedy if they deny you of you asking them?
So if you bring a writ of certiorari, to the Supreme Court of the United States, what you're saying is that there is a lower court decision that exists, and we would like you to review it. That is invoking the court's appellate jurisdiction. Because how can you invoke original jurisdiction if the only way that you can go to that court is by saying, oh, there's already a decision made? Right? So Congress made you forget about the whole original jurisdiction, the existence of it, because they said, oh, the only way that you can go to the Supreme Court is through their appellate jurisdiction. Thus, they legislatively foreclosed upon our ability to be able to use original jurisdiction, because they told all of you the only way that you could petition them now is by going through their appellate jurisdiction. Therefore, you can never invoke original jurisdiction. That's why we had to go and find a different writ, a different mechanism to be heard. That's why we use the habeas corpus as opposed to a certiorari in this, is because if we used an existing case, all we would be doing would be invoking the court's appellate jurisdiction. And no, we want their original jurisdiction. We're not going to go to that court and say, oh, well, there's already a decision made. Please review this lower court's decision. Because no, we're going there saying that state had no authority to be able to do anything at all. Therefore, all action of the state is unconstitutional. That's why we're using the habeas corpus, is because the state never had the authority to even perform the arrest. Right? They have no authority to do any of this.
So again, I'm arm length, but I wanted to kind of bring this out to sit and think about the process of what they are doing, right? What did we do before the Bar Association came in the 1840s? What happened before then? Okay, sit and think about it. And now all of a sudden, we're not even allowed to give legal advice, even though we didn't sign a bar card contract. Who are they to order such crap, right? They do not have control. I do not have a nexus attached to the bar union for them to give me an order that I cannot give legal advice. They're so far dumbing us down. That being said, I'm not an attorney, not giving legal advice. Educational purposes only. Okay? And anything I say or do, you just take it with a grain of salt. This is out there to get you start thinking what's going on. When we challenge jurisdiction of the court and they just automatically say they have it, that's because they don't want you to know that you need to have that sent to the Supreme Court. And yes, would it be full? They left the numbers open. There can be more than one Supreme Court, y'all. All right? They could.